Hello girls, now we'll be moving on to our next topic, that is annual report of directors. Now in your annual report of directors, according to section 217, so basically when you're sending an annual report of the directors, you have to attach this report with the balance sheet. Okay, when you're attaching it with the balance sheet, it has to be sent to all members while you're giving the notice for the meeting. And this particular report has to be dated like when the report is being prepared, and it also has to be signed by at least 2 directors. Now in that 2 directors, there'll be 1 director which will be a managing director, and the report will contain the following statements. Okay, now the following statements are as follows. Now, the following statements consist of a brief statement on trading results of the company for the past year, the amount proposed to be carried to the reserve fund, the amount proposed to be laid as dividend, material changes and commitments, if any, affecting the financial position, a statement indicating the name of every employee of the company. Okay, all of this information will the report has to contain all of this information. Okay, you have to by heart all of this. You have to mention as to what information the report contains. Now in the 5th statement, it says a statement indicating the name of every employee of the company who, okay, if employed throughout the financial year, was in receipt of remuneration. Okay, the employee who was who was employed in the company for a financial year and whose name was in the receipt of remuneration. Okay, whose name was in the receipt of remuneration for that particular year, in which the aggregate was not less than 3 lakhs. Okay, or now the limit has been raised to 6 lakhs per annum or 50,000 per month as per the new company, as per the company's amendment rules 1999. Okay, you have to make sure that you are including the name of the employee whose remuneration limit is as follows. Okay, now next is if employed for a part of the financial year was in receipt of remuneration for any part of the year at the rate which the aggregate was not less than 25,000 and now it is 50,000 per month. Suppose if the employee in that particular year was even employed for 3 months for a certain amount of remuneration and his salary was 25,000 or 50,000 per month, even his name has to be included. Okay, if employed throughout the financial year or part thereof was in receipt of remuneration in that which year which is in excess of that drawn by managing director or whole-time director. Okay, it was only drawn by managing director or whole-time director and holds by himself along with his spouse and dependent children not less than 2%. Okay, he should hold not less than 2% of equity shares of the company, indicating whether any such employee, if the relative of the director or name of the director or any such is the particular prescribed. Now basically this point states that there will be a person who will be employed during a particular financial year. Now that person can be a managing director or a whole-time director, and he will have shares of not less than 2% in a particular company, and he will also have nominees for his particular amount of salary if something happens to him. Okay, so this is what it states. Now next is the annual accounts and balance sheet. Now in the annual accounts and balance sheet, as you all know, balance sheet will always contain profit and loss account. Okay, it will also always be attached with the profit and loss account, but also auditor's report will be attached, and this particular balance sheet, profit and loss and auditor's report will be sent to each and every member of the company and also to the debenture holder at least 21 days before the meeting is being scheduled. Okay, before 21 days of the meeting, you have to send all of this information so that they refer that particular information and they come back to you and they are well prepared for the meeting as to what they have to discuss in meeting and everything. Okay, the balance sheet and profit and loss account must be signed by 2 directors, again as we looked into earlier. Now one will be the managing director. Amongst the 2 directors, one will be the managing director if any. Okay, the secretary if authorized by the board. If the board is giving permission, the secretary can also sign the report. Now after the annual general meeting is over, the secretary must file 3 copies of the balance sheet and profit and loss account along with other documents annexed thereto with the registrar within 30 days. Now once the meeting is conducted, the secretary must take down all the information that has been discussed in the meeting, must file 3 copies. Okay, 3 copies of whatever balance sheet is there, profit and loss, and along with the auditor's report, and will have to file all of these reports with the registrar of companies within 30 days of conducting that particular meeting. Suppose today a meeting is conducted, within 30 days he has to, the secretary has to register everything with the registrar of companies. Okay, now next one is chairman. Who is the chairman? Chairman is basically the person who is in the top management. He is the person who is giving you entire directions and issuing guidance to you all in the top management, right? Now in his speech, chairman explains the information given in director's report in detail. Okay, whatever report of directors is given during the time of meeting, chairman is explaining each and every report, explaining the report in detail. Okay, and the result and the financial position is also given to you all. Based on that, you also discuss the reviews of the company, the progress of the company. Okay, what are the factors that are affecting the company, whether the company is making profits, whether the company is making loss, and whether the company is able to generate employment opportunities. All of this will be discussed in the chairman's speech. Okay, the chairman will be discussing all of that, whatever things are affecting with the particular company. Now notice an agenda of the annual general meeting. Now notice an agenda is nothing but how the annual report is prepared and what is the agenda. Agenda means what they want to discuss. Okay, whether it could be any matters relating to any matter relating to the particular company, whatever issue is going on in the company regarding the shareholders, your debtors, your creditors. Okay, all of this will be discussed in the agenda of the meeting. And all of this, even if you are having something in mind, if you want to discuss any particular issue, you have to mention while you're giving the invitation to that particular meeting. You should mention it 21 days before the meeting. Okay, 21 days you should prior to the meeting, you have to mention each and everything to the people who are attending the meeting. Okay, to the members of the quorum. Now next is procedure of holding the meeting. Now now let's look into what is the procedure for holding the meeting. Now for the procedure for holding the meeting, now before the meeting you should make sure that the board meeting must be convened just before the annual general meeting. Okay, board meeting, whatever board meeting is there, it should be convened, it should be there, it should be kept before the annual general meeting to consider what are the matters regarding to your profits or rate of dividend or place, timing, etc. Okay, now the reports and the financial statements, notice, proxy forms, directors and auditor report should be printed and sent to the members. Okay, whatever you want to discuss or whatever information has to be given to the members of the particular people who are attending the meeting, all of this has to be printed and sent to each and every member whomsoever you are inviting for that particular meeting. Okay, now public notice of meeting should be published in newspaper. Suppose if it is a public company, as we looked in earlier, like if their capital is not if their capital turnover is in crores together, then all of them have to be then they should publish it in the newspaper saying our company is holding an annual general meeting on such and such particular days, and this also has to be done 21 days prior to the meeting. Okay, now next is secretary should prepare detailed agenda of the meeting. Chairman's speech. Okay, a secretary only will prepare what is the agenda of the meeting. Secretary will prepare the chairman's speech. Okay, and also will make preliminary arrangements for dividend distribution. Okay, if suppose the company has made profits, then your dividends also will be distributed, and also preparation of dividend list as to who is to receive the dividend also will be prepared by the secretary. Okay. And also the next point is scrutiny of proxy form receive up to 2 days. Okay, whoever is supposed to attend the meeting, if suppose one person is not able to attend the meeting, who will be attending in replace of him, all of this has to be taken care by the secretary. All of this information has to be taken care of the secretary, and also all of this information has to be taken down, and it has to be duly registered with the companies of registrar within 21 days of the within 21 days of commencing the particular meeting. Now during the meeting, now what will happen? Now this was all before the meeting. What will happen before the meeting, how you prepare for the meeting, and all of that. Now what will happen during the meeting? Now everyone have come for the meeting. Now what is happening during the meeting? Now during the meeting, secretary will collect the admission card. Okay, everyone will be given an invite to attend the particular meeting. So while they are coming to attend the meeting, secretary will collect the admission card at the gate. Okay, and record the attendance. They will mark the attendance, whether this person we had invited, whether this person has come. Okay, tick. Okay, like that. Okay, there you will collect the admit card, you will record the attendance for that admit card. Now next is chairman will take the chair to conduct the proceedings of the meeting. Chairman will come and he will start the meeting. Okay, he will take care of the proceedings of the meeting. After which the secretary ascertains the quorum of the meeting. Quorum of the meeting is basically he will check who are the members who were invited and how many people have attended the meeting. Okay, now business of the meeting is taken up for discussions in the same order as stated in the agenda. Okay, whatever had been stated earlier while they had invited, only those particular discussions will be done. Now the meeting will be ending with the vote of thanks. The secretary will give a vote of thanks to the chairman. Okay, this is what happens during the meeting. Okay, now what happens after the meeting is, after the meeting the secretary will prepare the minutes of the meeting. As we looked into earlier topics also, secretary is very much secretary has to be very alert during the meeting and has to take down each and every information that they are discussing in the meeting, including the minutes of the meeting, okay, including the hours of the meeting, and he needs to get it approved by the board in the next meeting. Now, to implement the decisions arrived at the meeting, whatever decisions have been taken in the meeting, secretary needs to make sure that they are implementing those decisions. Okay. After which the secretary should file the annual accounts and balance sheet, annual returns, etc. with the registrar within the prescribed time. Now our meeting is over. Within 21 days of the meeting has been conducted, everything has to be signed everything has to be registered with the registrar of companies. Okay, so this is what with the procedure of the holding the meeting. That is what happens before the meeting, what happens during the meeting, and what happens after the meeting. Moving on to your next topic, you have extraordinary general meeting. Now, what did we look into as extraordinary general meeting? Any matter which is discussed apart from the ordinary matters, for that extraordinary general meeting will be called, right, a special meeting. Now, what is extraordinary general meeting? As per the meaning, it says every general meeting. Okay, every general meeting other than the statutory meeting. Okay, every meeting except for the compulsory meeting, that is statutory meeting, which will be conducted for the first time after the formation of the company. Okay, so every general meeting other than the statutory meeting and the annual general meeting, okay, any meeting other than the statutory meeting and annual general meeting is called as an extraordinary general meeting. Okay, is called as an extraordinary general meeting. Now, such a meeting is generally convened for transacting some special or urgent business. Now, if you have to take any necessary or important decisions, okay, and you cannot wait for annual general meeting, and in case if your statutory meeting was already conducted before, now if you have to take any decisions, if you have to come to a conclusion of a particular problem or something, you will be calling an extraordinary general meeting. Okay, for example, this meeting may be convened for alteration of memorandum of articles, if you want to make any changes in the memorandum of articles, or if you want to alter your share capital, or if you want to remove the director before the expiry of his term. Why will you remove a director before the expiry of his term? If because of misconduct or misbehavior, if they're not carrying out their duties and responsibilities correctly, okay, or during that time you will be calling for an extraordinary general meeting and you will be doing all of these particular things. Now, who can call an extraordinary general meeting? Now, extraordinary general meeting can be called by the board, or by the board on requisition of members, requesting of members, or by the members themselves, or by the company law board. Okay, these four people can call for a general meeting. Now, why does the board call for a general meeting? Now, board will call up a general meeting. Now, who are the people who are in the board? The board of directors. Okay, the board of directors, if the article of companies provide, can be called, so provides, shall be called an extraordinary meeting whenever it thinks by passing a resolution. See, in case if the board of directors, in case if you have an issue with the board of directors, and if you want to remove the board of director before the term period, the board members can call for the extraordinary meeting in case if the matter is very important by passing a resolution saying, now we've taken a decision that we want to conduct an extraordinary general meeting, so and so people please attend the extraordinary general meeting. The next person who can call for it is by the board on requisition of members. If the members are requesting, or if the members are demanding to have an extraordinary general meeting, okay, when the members are requesting or demanding, then the board has to send a letter of requisition, letter of request. Requisition means request, which is signed by members holding not less than 1/10 paid up capital of the company. Okay, if only the members who are holding, only the members can call who have company capital wherein they are holding 1/10 of the paid up capital of the company, and wherein they are carrying even voting power. Okay, these people can call. and these people can sign. Okay, if the company has no share capital, members representing not less than 1/10 of total voting rights. This is when the company has capital, and if the members are holding 1/10 of paid up capital and voting power. But in case the company does not have voting, suppose if the company does not have share capital, then there will be members who will not be less than 1/10 of the people and will have voting rights also. This was the second person who on basis of sending a letter of requisition, they will be calling a board meeting. Now next is by the requisitionists. Okay, if the board fails to hold a meeting within 45 days of the deposit of requisition, okay, the requisitionists themselves will call for the meeting within 3 months from the date of requisition. Now suppose if the board members have requested to call for a meeting, but the board will fail to call for the meeting within 45 days. So what the board members will do is they will only call for the meeting within 3 months of the date of requisition. Suppose if they requested on a particular date, within the end of 3 months they will call for the meeting themselves. Okay. Now next is by the company law board. Now by the company law board, under section 186 of the act, the company law board may order on holding the extraordinary general meeting either on its own initiative or by the application which is made by the board, by the director and any member entitled to vote at the meeting. Okay, in case if the particular person has been requesting, if the members are requesting for an extraordinary general meeting, then an extraordinary general meeting will be conducted, or the extraordinary general meeting can even be called by the company law board depending on the matter that they have to discuss. Okay, now for the same, now extraordinary general meeting, the notice for this particular meeting, again it should be given 21 days prior, and it should also be published in newspapers. And also if the special resolution is moved and meeting, the text resolution should be accompanied by the company notice. Okay, whatever discussions have been made, whatever information is being discussed, all of this information has to be recorded, and the notice of the meeting has to be given 21 days prior, and also the notice of the meeting has to be mentioned in the newspaper. It has to be published in the newspaper. Now next is your procedure for holding an extraordinary general meeting. Now the procedure for holding an extraordinary general meeting is, firstly, if the meeting is held at the request of the director. Okay, if the requisition of director, that is nothing but request of the director, then the secretary sends the notice to the members. Okay, if directors are requesting for the meeting, then the secretary will send the send the notice for the particular meeting for the members 21 days prior. Okay, the notice is also published in newspaper, and secretary will deal with whatever the agenda is, the chairman's speech as we looked in earlier, the secretary will look after it. Next is if the meeting is held at the requisition of shareholders. First is on the request of directors, secretary will be there. Okay, secretary will send a notice 21 days prior. Now on the request of shareholders, the secretary ascertains whether the requirements of the act have been compiled with and will convene the directors meeting to decide the date, place of the meeting. Okay, they when the shareholders are requesting for an extraordinary general meeting, the secretary will see if the director or the directors are also agreeing to the same, and whether you can conduct a particular meeting, and when if you are able to conduct, what is the date on which you can conduct, what is the place in which place you can conduct, and what is the time of the meeting will be decided by the secretary in consultation with the directors. And the meeting will be held within 45 days of the deposit of requisition. Within 45 days, now suppose a shareholder has requested today for an extraordinary general meeting, within 45 days the meeting will be conducted. Okay. Now next, at the meeting, the chairman, now when the particular meeting is going on, the chairman will ascertain whether the meeting is duly convened and properly constituted. Okay, they will say, the chairman sees if the particular people who have to be called for the meeting and have been called, and whether the agenda has been properly fixed. Okay, now the chairman will proceed as per whatever the agenda, whatever the discussion has to be made, whatever was the goal, whatever the matters had to be discussed, the agenda, as per that agenda he will carry on and proceed with the meeting. Okay, now before moving on any resolution, the chairman will explain the need and advisability of passing a resolution. Suppose if they are discussing any matters relating to dividends or profits of the company, so before taking a proper decision, the chairman will explain as to why the decision is being made and what can be the best possible alternative also, and how you can put in your votes and declare the results. Okay, the chairman will explain each and everything effectively. Now after the meeting, the secretary must file the copy with the registrar. Whatever the meeting has been done, whatever discussions have been made, and whatever decisions have been taken, all of this have to be filed by the secretary, and the secretary should register this particular file with the company registrar within 30 days of the particular meeting. Now, the minutes of the meeting should be prepared and approved by the chairman in the next board meeting. Okay, so this is how the procedure of holding an extraordinary general meeting is, and whatever the matters will be discussed. Now, next is your class meetings. Now, class meetings are basically those meetings which are held by a particular class of people. It could be shareholders. Now in shareholders, you will have equity shareholders, you will have preference shareholders, you will have debenture holders. Okay, these are the classes of people. Okay, these are held only because if they have any matter, or if they want to get it approved by any special resolution. It could be only a preference shareholder meeting, or it could be only a equity shareholder meeting, depending on the class, which class they belong to. This is known as class meeting. Now next is meetings of debenture holders. Now meetings of debenture holders is only the debenture holders will come. Okay, the meeting of debentures holder is called by the company itself. Okay, why are they called? Because they have to discuss any matters relating to interest. Now interest to debenture. Okay, or any such rules and regulations which have to be discussed in the trust deed. Okay, during if you have any sorts of discussion or information, then the company itself will call for a debenture holder meeting and have a discussion with the debenture holder. Now next is meeting of creditors other than winding up. Now other than winding up, meeting of creditors. Now when will the company be able to repay their loan? Okay, in case if they have any dispute with the creditors, if they have any sorts of misunderstandings with the creditors, then the company itself will call for the meeting of the creditors. Now meeting of creditors and contributors. Now meeting of creditors and contributors are nothing but when the company is going on for liquidation, a meeting will be called by the creditors and the contributors. The company will call whoever the contributors to the company are, and whoever the creditors are, they will call them. They will discuss all of the information and necessary issues. They will tell this is the so and so profit which has been earned by the particular company, and wind up the affairs of the particular company by distributing their shares or their interest on which they have borrowed or lended the amount of money. Okay, so this is how we come to a conclusion of extraordinary general meeting.